Пане Іване.
Так. Вітаємо вас на другому етапі
Welcome at the second stage of our selection to the High Qualification Commission of Ukraine, Vladyslav. At the interview stage,
з вами проводиться конкурсною комісією у повному
the selection commission is holding this interview in its full composition. Stephen Markman, me, Ivan Mishchenko, Sergei Varlanov, Ivan Mezentsev, Petr Zhezhny, and Robert Burheisen.
Якщо наша з вами співбесіда, пане Владиславе, буде
In case our interview is interrupted for some reasons, we will definitely continue it on some other day and we will communicate and agree upon the time. The commissioners will ask you questions. Please give concise answers, and the commissioner can actually limit the time of your answer. The rapporteurs at your interview are me and my colleague Stephen Markman. We give all our candidates a chance to have an introductory speech, and of course there will be no exception. So please tell us about your motivation, why you decided to participate in this selection, and what ideas you have got concerning the work of the new HQCJ and the judiciary in general. You're welcome. You have up to 5 minutes, Vladyslav. Good afternoon, dear commissioners. In my introductory speech, let me stress the positive traits of character and positive characteristics that make me distinguished in the background of other candidates and that enable me actually to participate in this selection with all my due respect for other candidates. So, as you can see from my CV, I've got experience of work both in theory and in practice. I started working with the trial court where I got acquainted with the work of the trial court, local court, the problems that it was facing back then. So I've got some practical experience of working in court. I also worked as a practicing lawyer, and the experience of being a practicing lawyer allowed me to accumulate sufficient practical experience and to get the empirical basis for my further scientific research. Then I worked as an assistant in organization issues. I worked as an assistant director on organizational matters. I learned to work in a team, and I learned how to work with documents. So I think that this experience helped me to become the head of one of the departments. And I also worked in the Academy of Legal Sciences, where I dealt with advanced training of of people holding managerial positions in the field of education. And I was teaching my own course, developed by me, entitled Academic Integrity and the Novelty of Anti-Corruption Law, the problems of corruption in the field of education and ways of overcoming it. And since November, I've been working at the Scientific and Research Institute affiliated with the Academy of Legal Sciences, and my functional duties involve development of draft laws upon the request of judicial authorities, as well as provision of scientific and expert opinions and writing analytical notes. That's what we do upon the requests coming from judicial authorities. I'm a member of 2 specialized scholarly councils on the presentation of PhDs and doctoral theses. I've got several postgraduate students who have presented their PhD thesis, and I was their supervisor. I participated in the development of some amendments to the law on the judiciary and the status of judges and some other laws, and I'm a reviewer in 2 foreign journals. And I'm also a reviewer of a lot of other publications, and I've got my own publications which are dedicated to analysis of the role and place of the High Qualification Commission in the system of the judicial authorities. The second publication is dedicated to interaction between the locals, between the self-government, judicial self-government bodies, and interaction of these bodies with other state authorities of Ukraine. I've got zero tolerance to any manifestations of corruption and to corruption in the field of education in particular. Here I can talk about academic integrity because me and my students have never had any comments made by anybody concerning plagiarism or things like that. So I think that my teaching and managerial experience, my organizational skills, my theoretical and practical background entitle me to participate in the selection and to duly perform my duty related to the development of effective judiciary, as well as enable me to make assessment of incumbent judges and judicial candidates, because this is going to be the objective of this body.
Дякую, пане Владиславе.
Thank you, Vladyslav.
У вашій біографічній
In your CV,
довідці зазначено, що ви
it is
маєте,
indicated,
це ви, власне, вказали,
well,
що
actually
ви
you
маєте
indicated
досить
this, that
багато
you
нагород.
have got quite a lot of awards.
Ви заслужений юрист
You are
України.
a merited or an
У
honored
вас
lawyer of
різні
Ukraine.
грамоти,
You've got different
почесні
diplomas,
відзнаки
honorary
від
diplomas,
Верховної
different
Ради
sorts of
України,
awards
від
from the
Уповноваженого
parliament,
президента з
from
питань
the
реабілітації учасників бойових дій, Міністерства
presidential
освіти і науки і так далі, і
ombudsman
так далі.
on
Їх
combat
досить-
actions,
досить велика
rehabilitation after
кількість.
combat actions, so quite a lot of them.
Майже всі вони
almost
були
all of
отримані вами
them
в період
Were the awards that you got over the period of
2019-2021
2019-2021.
Скажіть, будь ласка, а чим
Could
так
you please
вирізняються
tell us
ці роки у вашій
why were
професійній
these years
діяльності,
so much
що
distinguishing
майже
in
всі
your
ці
career that
почесні
almost all
відзнаки
these
ви отримали
awards and
саме
honorary
протягом цих двох
diplomas
років? Що там
were
такого
something you got over that period?
відбулося?
What did you do over that period of time that was so special? Thank you for your question. The point is that over that period of my activity, well, before that period, before the age of 45, my principal position was not to get any awards from anyone. That was a matter of principle. And I worked as assistant director, and there were several suggestions that I should get a reward, but I refused. I rejected these awards. But it so happened that after I got their degree or the title of the honored or merited lawyer of Ukraine, I found out that in a lot of applications you need to indicate your awards. That somehow coincided with time, and everybody kept asking me, so does it mean that you haven't earned any awards? And then I understood that probably I should not refuse to get awards and honorary diplomas just to have something to fill out this section with. And I hope that I have obtained those awards for specific merits, but I don't think that I should speak on every single award to explain why I got it. For example, I'm a member of some national association of lawyers of the bar, and I have some cases that I won, so I think that these are my achievements that are remunerated in that way. I'm not doubting your merits and your achievements. My question was related just why was it all over that period of time, so you have actually given the answer to the question.
Ви продовжували їх отримувати саме в цьому році. Тому моє питання було, можливо, щось в 2019 році таке сталося.
The question whether something happened in 2019, but you have actually explained. Yes, I just understood that I need to have those words. I don't need to reject them.
Знову ж таки, в цій же самій біографічній довідці ви
In your
зазначаєте, що ви
CV,
є
you also indicate
заступником
that you
голови
are
Союзу юристів
deputy
України.
head of the Union
Чи
of
правильно я розумію,
Lawyers
що
of Ukraine.
цей
Do I get it
Союз
right
юристів
that this
України
Union of
очолює
Lawyers of Ukraine is headed by Sviatoslav Piskun, the former prosecutor general? Yes, you are right. I know what you are talking about. let me tell about some part of my activity related to the law on languages. This is the event of 2012, if I'm not mistaken. But, I joined the union only in 2020. So I didn't have anything to do with that law and with Mr. Piskun. And to tell the truth, I feel a pleasure. I feel honored to be deputy head of that union. We have several deputies, in fact. One of them is Koval Katarina, who was a lawyer and who used to be a member of the Commission on the Election of the Specialized Anti-Corruption Prosecutor's Office. And Kropachova Nina is the first ombudsman and the member of the High Anti-Corruption Commission. But Sviatoslav Piskun was preceded in this position by Mr. Yevdokimov. This is a well-known person, the head of the High Council of Justice. So I'm actually proud of taking this position of deputy head of the union on scientific matters. I'm the deputy head of this on scientific matters, and I represent our union at different conferences, which are scientific and practical conferences. And I actually replaced Mr. Alexander Petreshin, who is a newly elected judge of the Constitutional Court, because he was also a member of the Union of Lawyers. So it's a pleasure and honor for me. And let me also add that I have to be a member of some civil society organizations, public organizations, according to the resolution of the Cabinet of Ministers. And I'm a teacher, lecturer, so there is a requirement like that for us. Okay, clear. Let's go over to your motivation letter. Among the suggestions that you voice concerning the future work of the judiciary, in particular the HQCJ, you suggest the Institute of Mentorship, when the experienced judges help their newly appointed colleagues to somehow adjust to the job. And as far as I understand, this notion is available in Canada and in the US in a silent format. But don't you think that in the Ukrainian context, this mentoring or mentorship could be perceived as a subtle influence on the impartiality of judges, even though they are fresh men? What would be your reaction to that? Well, thank you for your relevant question. I've been thinking about it. I would say that the National School of Judges of Ukraine, that is dealing with the training and advanced training of judges and judicial candidates, has introduced mentoring on its own level. It develops methodological guidelines. There are some manuals on that. I've read them. And I just suggest that this institute is affirmed in the law of Ukraine on the judiciary status of judges. Why? Why do you think it is necessary? I know that there has been a discussion of the optimization and reduction of the number of procedures and acceleration of the selection procedure, because we need to fill the vacancies very quickly. So most probably the timeline for the training will become shorter, considerably shorter. But I think that anyway, the judge should not just be introduced to the court and that's it. Just work there, please. No, he should have a mentor. That could be a mentor in the court where he works. That could be a chief judge who, at the meeting of the judges, suggests some candidacy, some judge who is experienced enough and could do some mentoring for this person for a year, let's say. Here we mean only consultations, recommendations on some dubious situations which this young judge has doubts about, because that is all about responsibility. If it is established in that way, if there is this sort of connection, At a certain stage of activity of this new judge, this will be useful for him. I think that should last for 1 year. Thank you.
І ще одне
And here is
питання,
another question.
після чого я передам слово
And after
своєму
that, I will give the floor to my
колезі.
colleague.
Нам необхідно прояснити
So we
одне
need to
майнове
clarify
питання,
one property
яке
issue
пов'язано,
that is related
я його сформулюю, я
to the following.
без
Let
зазначення
me
персональних
phrase
даних.
it without
Питання полягає в
indicating
тому,
some
що,
identity, personal data.
ваша
So the
колишня
issue is that your
дружина
former wife,
проживає
your
в
ex-wife,
квартирі, яка
lives in the
належить вашій
apartment
мамі.
which belongs to your mother.
І наскільки відомо комісії,
And
ваша
as far as
колишня
the Commission
дружина не
knows,
сплачує
your
вашій мамі
ex-wife is not
орендну
paying
плату
any rent to your
за
mother
проживання в цій квартирі.
for living in that apartment.
Як ви це прокоментуєте?
What would be your comments on that point? Well, thank you for your question. I can briefly comment on that point. First of all, my ex-wife lived there for a period of time. That's true. But as far as I know, last year she received the apartment from the state, and she no longer lives there. And she lived there because, you know, buying of an apartment was a dream for her, for me. I mean, I thought that I would one day live and work in Kyiv. And when my mother bought an apartment without my agreement, well, that's her own business. She bought it for me. But I worked in Kharkiv and I worked in other cities. That's why back then, though the apartment was bought by my mother in 2017, I actually did not live in it. The apartment was just staying without any people residing there. And as far as I know, my mother still treated my ex-wife, even after divorce, in a very good way. And, well, you know, if the apartment is, so to say, idling, you still need to pay some utility bills. And I didn't have this chance to live in this city, so in Kyiv, and that's why my mother told my ex-wife that she could be living in that apartment in one of the rooms because repairs were conducted in the other rooms, and in that way my wife actually paid the utility bills. So that was a kind of arrangement. My mother actually leases some apartments and gets rent, but in this case she didn't get the rent, but she just got their utility bills covered by my wife, my ex-wife. Okay, thank you. Let me now give the floor to my colleague Stephen. Stephen, you're welcome.
Thank you, Mr. Chairman, and thank you, Professor Teremetskyi, for being here today. We appreciate your participation in this competition. You did not indicate in the information that you've provided to this commission that your former wife was a member of the district court in Kyiv, did you?
Yes, that's true. She works as a judge in one of the district courts of Kyiv.
Well, as you're probably aware, the High Qualifications Commission, an institution to which you're currently applying, has a certain relationship and a certain authority concerning judges, including some of a disciplinary character. Do you think that might have been a better thing to have done to inform us of that relationship?
Thank you for the question. Well, this is the information that is just common knowledge. I mean, information of general access, public information. I don't remember whether I mentioned this, but sorry, I just thought that this is the information you know. I did not, that's why I didn't indicate it. And there was a question I was asked about the form in which we communicate. So I answered this question and provided the explanations. And by the way, I would say that normally we communicate with her on some research topics because we have joint publications. I'm Doctor of Law and she is PhD of Law. So she sometimes addresses me with scientific issues because I can kind of instruct her on that point and give some consultations.
I think it would be accurate to say that you did not provide that information, at least to the best of my knowledge, as to whether it's common knowledge that you were married to a member of the current judiciary. It certainly wasn't common knowledge, I think, to all of the members of this commission. So I ask you again whether or not it might have been more prudent to have mentioned that, given the relationship between the High Qualifications Commission and the work of your former wife.
Well, if she was my wife now, probably yes, but she's my ex-wife, and for many years we have not been living together. And I have had some other relationship over that period of time and people with whom I have been living. That's why I could not have indicated all of them, because I should have indicated all of them then. Some of them also work in the judiciary or in the law enforcement bodies.
She is, in fact, your former wife, obviously. That's certainly correct. But as Judge Mashenko has just indicated, there is the somewhat odd situation that your wife was purchased an apartment by your mother just in 2017, and again, given all the circumstances of the relationship, I suggest it might have made sense again to have brought that to our attention. But concerning your mother again, my understanding, the information that we have is that on three not too distant occasions in 2018 and twice in 2017 and twice in 2018, your mother purchased property in particular places having a total value of approximately 2.8 million hryvnia. According to the State Fiscal Service, from the period 1998 to 2022, the total income of your mother and your father put together was approximately 1.6 million hryvnia. My question is, do you have any information, and again, would it have been best if you had provided that information, if you have it, concerning the sources of origin for the monies that your mother spent on these properties, which was nearly 1 million hryvnia more than the income records show going back to 1998? Do you have any understanding of the source of the expenditures for those properties?
Thank you for the question. That's really true that I was asked this question. I looked through the information and I took some documents that are related to this issue. What can I tell? I can tell that my mother inherited in 2017 from Yuri Zhukovsky, who died, an apartment, a car, and a garage, and a land plot in some gardening society. She sold this car. Then, as far as the 3-room apartment is concerned, she leased it and was getting rent. And she also got quite an amount of money for the car. She had the power of attorney, and I've provided this information to you. This was the power of attorney from Mr. Zhukovsky for getting the money. This was the power of attorney issued in her name because he entrusted my mother with dealing with the task of dealing with his financial assets in bank accounts, and he had quite an amount of those financial assets. And, one day he also gave me $50,000 $500 to cover the difference between my old and the new car.
Did you provide those documents to us, Professor? Have you provided the documents to us that you just showed on the screen?
No, I have not provided those documents. They are here. I will explain you why, because there are too many documents. Let me finish with the information about this Mr. Zhukovsky, who was a rather rich man. So there was some money in bank accounts my mother could also inherit. But, you know, according to our law, cash is not to be inherited under the will. So Mr. Zhukovsky, before his death, issued this power of attorney, and therefore she got all the money from his bank accounts, which was quite a lot. Also, my mother was looking after the elderly people. And she had an agreement with them that they will leave their apartment to her after their death. And here is the right to inheritance.
It's very hard for us to read those documents on the screen. Let me say, Professor, we're asking these questions. Can I just interrupt for 1 second? We're asking these questions because we want to be fair to you. We don't want to assume the worst. I would encourage you to share those documents with us as quickly as you can, even if there's a lot of them, as you say. But concerning the property that your mother allowed your ex-wife to live in, are you familiar with the decision of the Ethics Council regarding the nature of that relationship and how they addressed your ex-wife's circumstances when that issue came up during her evaluation? They decided that your ex-wife had not provided sufficient evidence in their judgment to disprove reasonable doubt about the circumstances and the validity of that transaction. If that's so, and I believe it is so, is it possible that this commission, the selection commission that we have convened today, would reach a different conclusion regarding the same conduct? Is there a distinction between how your wife was treated by the Ethics Council and how this commission should treat your relationship in this affair?
I think yes. During the selection, my ex-wife didn't have this list of documents, which confirmed the legitimacy of the acquisition of this apartment by my mother. And that's why probably the Essex Council reached this decision. But in the materials of the case, I have actually copies of the bank agreements. I provided them to you, and you can see the amounts of money there.
Okay. Well, as of right now, we don't have the documents that you're showing on the screen, so there's no distinction, at least for the moment, between what we have and what the Ethics Council probably had at that time. Since September 2018, we also have information that, of course, you've been working as a professor in Ternopil. At the time of your declarations in both 2019 and 2021, there's no indication of any real estate in which you could have lived in that community. Can you explain why there was no housing at all that you declared in Ternopil during those two declaration periods? Was that accurate?
Well, let me try and provide the explanations. The point is that the first declaration for 2019 was submitted by me because I intended to participate in the selection for the Constitutional Court, but I changed my mind. I did not participate in the selection. And that's why I was not very scrupulous about my calculation in terms of the amounts of money I had back then. Because I knew that I would not participate in this election, and I was all the time on business trips, and some part of my money was actually with my parents just for security purposes. And as far as the declaration for 2020 is concerned, I did not submit the declaration as such because I don't have the duty to submit the declaration. But for 2021, I already submitted the declaration because I knew that I would participate in this election. So I counted and calculated everything. As far as the real property in Ternopil is concerned, real estate, yes, I really worked in the Western Ukrainian University for 4 years. And I really did not indicate any real estate there because under Article 46, I had to live more than 183 days in that city within the year, but it did not happen. I lived fewer days, because I was a lecturer there, and I was actually paid by hour. I worked by the hour, which means that I was not staying there all the time. And also, you know that there was COVID, and I just had to come for lectures or for the meetings of the specialized PhD presentation council. And I sometimes even lived in the hotels of Ternopil.
Okay. Well,
And let me also mention that I was not a full-time lecturer. I worked just with one part of the load. It was only, as we call it, not even part-time.
Let me ask you one more question, Professor, and let me move to a different subject. You quote a gentleman by the name of Plato in your motivation, and I don't know if he was a judge selector or not in ancient Athens, but he said something that you quote affirmatively: "The judge rules over the souls with his soul." Is this what you'll be looking for, too, if you're elevated to the High Qualification Commission?
Thank you for the question. It's a really philosophical question. There is also another statement that you don't have to condemn anyone or judge anyone, and you will not be judged yourself. But it's a different statement. I don't think that this statement could be applied to judges, because it's their duty to judge some other people and to pass fair and just decisions. I think that my duty and the duty of the HQCJ is to do this thing, and my qualities, characteristics, and moral competences should be even higher than the ones I will be trying to find in the judges I select. And then this means that I will have to deal with the selection of the people who will be ruling the lives of other people in a way. So this is a moral burden, but it's a challenge, but I can cope with it.
Okay. Well, thank you again for your time, Professor. Let me turn it over to my colleague, Mr. Broekhuizen. Thank you.
Hello, Professor. Robert Broekhuizen. When I read your motivation letter, there was one thing that drew my attention. You know, of course, that we asked you about your vision of the future of the judiciary, and you say that the judicial system should be comprised of honest, decent, and professional judges. I think we all agree to that. That's also the reason we have this exercise. And that it is necessary to check the compliance of the lifestyle and judicial candidates. And that's what we do. And that's also the reason that my colleague Justice Markman asks you those questions. And then you say, it's worth establishing quota for candidates who have worked as judge assistants. As they have good experience, their training before appointment will be less time-consuming. When I think about that, I find this statement that does not satisfy me, because what we're trying to do, of course, is to enhance the judiciary by selecting better and more honest judges. And the judge assistants who work in the judiciary are people who are often, let's say, work as judge assistants for quite a considerable time for the judges, so they are raised in the system and they get used to everything that is normal within that system. And further, you can have some doubts whether, let's say, the fact that the judge hires an assistant is sufficient qualification for someone to become a judge later. I can tell you that in the system where I come from, everyone will look critically at judge assistants because often they do not pass the bar to become a judge. Sometimes they do, but very often they don't. So maybe you can respond to what I say and whether you believe that your vision to especially have quota for candidates who worked as judge assistants is going to change the judiciary in Ukraine to the positive.
Thank you for the question. I've also been thinking about this issue because I know that there is an ongoing discussion about this, and maybe some changes will be introduced into the legislation in this respect. So what I think in this regards is that now we think that we need to shorten the timeline for selection and for training in the National School of Judges, because now it's 12 months for everyone. But first of all, people tend to say that it should be reduced twice, like to up to 6 months, in particular for assistant judges who consider to be better prepared. But let me mention a couple of things. Why did I reach this conclusion? I always tend to analyze different legislative acts and different provisions. And by analogy with the representatives, the applicants for the High Council of Justice, I decided that, well, there is the quota. There should be the quota, actually there is the quota, both for the HQCJ and HQCJ, that judges are half of this commission. So I suggest that there should also be quota for assistant judges. I don't know whether it should be 50% or 20%. That should be decided by the lawmaker. But availability of this quota is something I would consider to be relevant, in particular in today's conditions when we really need to very quickly, but without violation of the quality, to fill in a lot of vacancies of judges in Ukraine. But for assistant judges, there should also be some requirements set. I think that this person should have worked in court as an assistant judge for 3 or 5 years. It won't go that you just work for a month and that's enough for you to be qualified, because experience is something that you gain with years. And there should be, of course, no other preferences for assistant judges, but for this, just the quota principle, and that's it.
Yeah.
Thank you.
Yes, I listen to what you say, and of course, I don't know anything about how the Ukrainian system works. But as an outsider, I would say to you that if you ask about your vision and to increase the level of public trust, is the one thing you shouldn't do is to have a mechanism that clearly fails in the selection of proper judges. Keep it as it is and even give quotas for that system. I would say that's upside down. there's one thing you should do. I would say, and not my opinion, but just a statement to you where you can react on, that you should get rid of the possibility that without lots of vetting and investigation into those people who are assistant judges, that you only promote them if it is shown and proven that those candidates are indeed worthy candidates to become a judge, and not just automatically because someone has been assistant for 10 years promote them to the position of judge. If something would damage public trust, possibly it would be that.
Well, I probably meant a little bit different thing. I meant that all the other procedures remain in place for assistant judges, but for quota. Whether it is 20% or 50% of how much, I don't know, but all the other requirements and procedures remain the same, and that's why I say that I actually took it from the legislation on the status of the High Qualification Commission and the HQCJ, whether there is 50% quota for judges, but the judges are undergoing this selection, so there is just a quota, but the procedure is the same. So I'm stressing that there are no other preferences or benefits or any reliefs for them, for assistant judges. That's what I mean. There should be no other preferences, because otherwise that will mean violation of the Constitution about the equality of everyone. This is the principle enshrined in our Constitution. We should not violate it.
Okay, thank you. I will pass the floor to my dear colleague, Teremetskyi.
Somewhat in a related area, you indicated in your opening remarks to our commission, as I understood it, that because of the pressure to fill the huge number of vacancies, you would recommend or consider shortening the term of the study that judicial candidates receive through the National School of Judges, I presume. I take it that you, as a professor of anyone, would understand the value of education and the contribution that education makes to a student's successful career. Now, with that foundation, would you not be risking sacrificing quality in the appointment of new candidate judges for quantity just to fill a position? Would that not be a concern to you?
Yes, thank you for the question. So I was trying to compare my own experience as a lawyer, remembering how I was passing my qualification exam to get a license to practice law. I was already trained. I was prepared for the qualification exam, and having passed it, I got my license to practice law, and I immediately started working as a lawyer. So I got prepared. I had a certain level of qualification and experience of work. The requirement was to have at least 2 years of experience. And in order to become a judge, as you may know, the requirement is to have at least 5 years of experience in the field of law. So it's presumed that a person already has the experience and a certain level of knowledge, that they understand that they are getting ready, both professionally and morally, to hold the position of a judge. Then they pass the exam and they continue on with the training. Well, it may be different with the lawyers. I agree that training for judges is more responsible, and of course we need to have the training in the National School of Judges. But if we look at the timeline, I'm just suggesting that we shorten the duration but introduce mentors, so that we have some kind of control, or rather support, so that a potential judge can have somebody who can help them with problematic issues, problematic professional issues. That is why I suggested this in case we are having shortened duration of training at the National School of Judges. If the timeline is different, it doesn't mean that we are forsaking the quality. We may have more classes per day. Instead of 3, we can have 5, for instance. We can have more intense training. But we can at the same time introduce the Institute of Mentors, so that future or those young judges have somebody they can approach with questions. I think that is important as well.
The problem with that suggestion or thought, it seems to me, is that these people who have these mentors are already appointed as judges. So if you shorten the period of education and you promote less education or more intense education, which again, either one of those impact the quality of the education, in my view, by the time they are appointed judges, you have a large risk that you will have less prepared, less educated, and therefore less capable, fewer capable judges who begin work as judges.
Thank you. I was also thinking about it. And I can tell you that we need to have some objective selection. What I mean by that is that I recently read information in one of the legal newspapers, and it said that 3 people who were appointed as judges in the year of 2020, they resigned. What does it tell us? It tells us that not everybody who will be appointed as a judge will be able to perform their duties in a duly manner. And that's okay. Things happen. And this is the kind of objective selection that I'm talking about. And in this way, the judiciary will have a self-cleanse, in a way.
Yes, well, it strikes me that there was an extraordinarily huge effort that was put forward for the requalification or the qualification assessment of judges. And the whole purpose of that, as I understood it, was to ensure that judges who were in the office of a judge had professional competence and integrity required to continue in the service of the people of Ukraine. Now you're suggesting a model where perhaps undereducated and underexperienced judges would have their education program reduced, and a mentorship idea is imposed. It seems to me that that is producing a situation where the qualification of some newly appointed judges may not be to the high standard that was hoped to be achieved by the requalification process. Do you see it differently?
Thank you. I have quite a different opinion. Unfortunately, under the circumstances, we will have to select a huge number of judges. For the first time in the history of Ukraine, we will have that many vacancies to fill. Probably we will need to break it down into several stages, and the workload for the new HQCJ is going to be huge. It's an objective factor. Yes, I agree with you that we cannot forsake the efficiency, we cannot forsake the quality. That's why we are not changing any other requirements. And I mean professional competence, integrity, moral and ethical qualities. All these things are also important. But I will not be repeating the same ideas. Yes, maybe we'll get some distortions in the end, but for that very purpose, we are going to have the HQCJ, and probably during the final stage, we will involve not just a psychologist, which I consider to be something of importance, but in addition to psychological testing, we will have an interview similar to the one that we are currently having, and the HQCJ members, in view of their experience, will be able to identify those judges who, in their opinion, are not worthy of being appointed. So I'm confirming your opinion that there are certain risks involved in this situation, and with that I agree with you.
Let me ask you one last question. I reviewed carefully the motivation letter that you sent us answering the 10 questions that we posed to all candidates. And many candidates have commented on the very important role that they see for the Public Integrity Council as a representative of society and the public interest in the appointment process. I did not see any mention of, in your motivation letter, any mention of the relationship and the role and involvement that the Public Integrity Council, in your opinion, should have with the High Qualification Commission of Judges. So what is your view in that regard?
Thank you for the question. Yes, indeed. I did not touch upon that in my motivational letter because there was a limitation in characters for our motivational letters, and I was actually counting all the characters while writing my motivational letter. But I do have an opinion. I believe that PIC is a body that we need to keep it, but at the same time, its legal status should be regulated better, not just the rights, but also the responsibilities. And we are currently having a debate within the legal community with regards to the status of this body, and we are discussing the possibility for expanding the mandate of PIC, the involvement of PIC in the assessment of judges. And I studied the state anti-corruption program developed by National Agency for Corruption Prevention, and I also studied the remarks with regards to this program submitted by the High Council of Justice. The essence of the remarks was about the HCJ disagreeing with the proposal to give additional mandate to PIC. The key complaint, according to HCJ, was that NACP try to change the status, keeping the title Public Integrity Council, and in fact it would be transformed into some kind of State Integrity Council, not Public Integrity Council. There was also a suggestion to create a secretariat of PIC that would be funded from the state budget, the taxpayers' money, and the PIC is a Public Integrity Council, and the right to become a member of PIC means that you don't get to be paid. You're not paid by the state. And I insist that in this context, well, I was reading some information with regards to misunderstandings in the work between previous HQCJ and PIC. There was no quality interaction between the two, and during the final selection of judges, the PIC even refused to provide its opinions. And I would like to prevent a similar situation from happening, so maybe we could develop a joint act on the interaction between HQCJ and PIC. In this way, we will not have any misunderstandings. We will regulate the situation as much as possible, taking into account the previous experience. Without this interaction, there will be no quality work, there will be no positive outcome. Thank you.
Thank you. I will now turn the matter over to my colleague, Mr. Mezentsev. I'm sure he has a question.
Yeah, I appreciate it. Thank you so much. Пане Владиславе, доброго дня.
Good afternoon, Vladyslav. Let us continue discussing the topic that has already been raised about the young judges resigning. So you mentioned that some judges appointed in 2020 already resigned. So as a person who has come along this way between the appointment and having a career of a professional judge, I can tell you what caused those resignations. Being a judge is always stressful. And a person who comes to this position after working at other bodies, law enforcement, prosecutor's office, etc., etc., a person who is a new judge does not really understand the level of stress, because indeed the position is very responsible. You make judgments and decisions in the name of Ukraine. So you represent the state while making your decisions. And this is a way to exert some kind of psychological pressure on you. And to tell you honestly, I was having some nightmares of me being a judge in the courtroom and listening to the arguments of both parties, and I was unable to come to a decision. And in 6 months, I stopped having those nightmares, and I shared this experience with my colleagues, and they told me that they had the same experience. So, in your opinion, what could prevent young judges from resigning? In some way, we need to help those young judges cope. So, what could we do? Thank you for this interesting question. I would talk about objective and subjective factors here. We cannot do anything about the subjective factors. A person may have this goal to become a judge, and they may do everything to achieve it. They can be well prepared as far as knowledge is concerned, but maybe it will be impossible for them to bear the stress. So maybe they are counting on a good salary, on a high status within the community, but once they start working, once they enter the courtroom, they will see the workload, and indeed, They may have a mental breakdown even, and how can we help such judges? There are some methodologies that help you relieve stress, so you can go to some relaxation rooms. A judge should take care of their health. They need to have some hobbies outside of work. So it's a complex of measures because a judge is still a person. There are also objective factors. Among those objective factors, we can do different things. As an academic, I, for instance, can write papers. I can introduce some draft laws on the improvement in the activities of judges and courts. So we must create such conditions for their work so the judges feel comfortable. So that they have this understanding that they will have to work with many documents. Well, this is a comprehensive question, and we need to help judges in any way that we can. Yes, thank you, Vladislav. Thank you for these warm, supportive words with regards to judges. So I have two more questions. When studying your declaration for the year of 2021, I saw that you have the right of use to 2 apartments in Kharkiv, one with the area of 32 square meters where you're registered, and one with the area of 48 square meters where you are actually residing. And both apartments are owned by your mother, as far as I understand. It's not the question of you residing in those apartments or not. I was a little bit frustrated with the value of those apartments. The first apartment was bought for 4,000 hryvnias in the year 2004, and the second one was bought in the year 2007 for $2,300. Could you please tell us, are these realistic prices for apartments in Kharkiv? Is it possible to buy apartments for such a low price? Yes, I can explain these prices to you. Let me explain. The apartments were bought in very bad condition. They were not fit for living. One apartment was in such a bad condition because the previous owner had more than 20 cats, and over a period of 20 years nobody wanted to buy that apartment. It was such in bad shape, the floors were rotten, the walls were in bad shape, so we did complete renovation of the apartment. Yes, we had a real estate agent who helped us find those apartments in very bad shape. And those apartments were owned either by people with very questionable social background, people who abused alcohol and things like that. So they didn't look after those apartments. So my mother bought these apartments, made renovations there, and then she rented them out. That's clear, thank you. So we have some kind of interaction with civil society organizations who on many occasions draw our attention to some inconsistencies. And we would like to have some of these doubts debunked. So Otto Maidan mentioned that you bought Mazda SX5 for $23,000 in the year of 2014, which according to them is a price which is too low. According to the data from your declaration, you bought the car in February of 2015. Is that correct? I need to clarify here. I had two cars of the same make. No. That's the car which you mentioned in your declaration, Mazda CX-5, bought in February of 2015. It was manufactured in 2014, so if we look at the date of purchase, you probably bought this car from a car salon. It was new, right? Yes, so I bought the first car in 2013 and then the second car in 2014. So let us talk about the car manufactured in 2014, bought in February of 2015. So you mentioned the purchase price of 656,000 hryvnias. Is that correct? Yes, I have the original of the agreement. Please don't show it for everybody to see. These are personal documents. So I checked the exchange rate in the year of 2015. So it appears that it cost $41,000. So a new car now costs $40,000. So I don't really see any issues with the price. Maybe the civil society organizations made a mistake while calculating the value. And finally, I have another question for you. You, as rather an accomplished scholar, you are a doctor of law at the young age of 39, and that's commendable. But you must know that the quality of legal education at different educational institutions varies. And many people are saying that we are having too many lawyers, more than we actually need. So, in your opinion, would it make sense for us to enhance the level of legal education, maybe have fewer law schools, and as a result have a better quality of our graduates in general? Do you share this opinion? Yes, thank you. It's a really relevant question. So there are two aspects here, the subjective and objective one. No. That's not what I meant. So I agree with you in saying that we could have fewer law schools. No, that's not what I said. I said that some people are expressing this opinion. Yes, well, partly I support this idea to have fewer law schools. Keep the Kharkiv Law School or Odessa Law School. I'm not promoting any particular law school. I'm talking about the oldest and the best law schools. But at the same time, we cannot prohibit other educational institutions to have their faculties of law. It's up to the bodies that issue licenses or permits to open these departments or faculties. So if a higher educational institution meets all those requirements, they will be given a license, and we cannot do anything about that. We can only amend our legislation. It can be done on the legislative level. Can we do it on the legislative level? I don't think so. So it should be a kind of natural selection. A person has the right to choose where they want to study. Maybe they can go abroad and study at a law school there and then come back to Ukraine. Yes, it's a good idea, but it cannot be implemented. Fine. I understand it now. I'm now passing the floor to our chair. Oh, we still have one more commissioner who hasn't asked their questions. Sergey.
Пане Владиславе, у мене буде такого змісту до вас запитання.
Vladyslav, I have the following question for you. Let us discuss your proposal about introducing the Institute of Mentors. It's an interesting proposal, and I would like to hear a little bit more about it, because you're suggesting for experienced judges to help the newly appointed judges, help them adjust to the new reality.
От в даному випадку даний інститут
So could you
наставництва
please tell us,
гіпотетично, чи може він порушувати
hypothetically
встановлений законодавством
speaking, this
принцип
institute
незалежності
of
суддів
mentors,
суду?
can it go against the principle of independence of judges? Yes, you are right. I understand what the implication here is.
Ця моя думка, щоб вона не була неправильно сприйнята.
I don't want to be perceived in the wrong way.
Для цього дуже важливо зробити запобіжники.
It is important that we have some safeguards on the level of law. Why have I developed this proposal? Many of my students are judges, and I talked to them, and some of them are young judges who've been working for a year, for 2 years, or 3 years, and they told me that when they started working as judges, they had many questions, and they approached the court president with those questions, and they were told that there was that kind of practice existing within the court, that this or that judge deals with questions of young judges. So should you have any questions as a young judge, you need to approach this judge or that judge depending on their area of expertise. So practically the institute is already in place unofficially. But there can also be a negative outcome when the court presidents may tell young judges to go to that more experienced judge, and the more experienced judge can influence what kinds of decisions are made by those young judges. That's not what I mean. A judge has no right to disclose the personal details of parties to the proceedings of court. So what I'm saying is that a young judge can approach a more experienced judge asking for advice on how to act within the law.
І наступне до вас запитання.
Thank
Скажіть, будь ласка,
you.
на вашу думку, ви як
My
науковець,
next question. So
який
you,
безпосередньо
as an
приймає участь у
academic,
розробці, безпосередньо тих нормативних
who
актів,
is
які необхідні
involved
для,
in the development
навчання,
of legislative
суддів,
acts
і кандидатів на посади
and
суддів. Скажіть, будь
documents
ласка,
necessary
як ви
for
вважаєте,
training
от
of
щодо
judges and
Національної
candidate
школи
judges.
суддів,
So if we
чи
look at the
потрібні
National
зміни
School of
безпосередньо
Judges,
саме в цьому?
do we need to introduce any changes there? Do we need to change anything about the training of incumbent judges and candidate judges? Thank you for the question. In my papers, in 2 of the papers that I published last year with regards to the judicial reform, in 2 of those papers, I stressed upon the need for a better interaction between HQCJ and the other bodies acting within the system of the judiciary, and that includes the National School of Judges. I think that this interaction must be regulated. It should be a kind of a joint act or a joint document. It is important that the issues of interaction are regulated within a joint document approved by all those bodies. So the HQCJ has close connections with the National School of Judges. That's why they need to have a joint act, a joint document where everything will be prescribed and regulated.
Добре, дякую, пане Владиславе, вам за
Thank you.
відповіді.
Thank you,
Зараз я
Vladyslav,
передаю
for
слово
your
голові
answers.
комісії.
I'm now passing the floor to our chair. Thank you, Serhiy.
Чи будуть ще запитання?
Do we have any additional questions, dear commissioners?
Please.
Professor, you have some very fine letters of recommendation. One in particular from Judge Rumientsov of the Samarsky District Court says that you've made significant contributions to the development of the modern judicial system. That's quite high praise. And I notice you've written more than 260 works, scientific works. Would you be able to identify one or two or a very small number of those that you think would be particularly helpful on your part if you were to be placed on the High Qualifications Commission, and might want to suggest that one of your colleagues read one of those works, one of those the best works that have added something to our understanding of the modern judiciary in Ukraine? Is there one that you take particular pride in?
Thank you for the question. So, if we are talking about academic papers, it's important that the papers outline not just those issues that exist in the judiciary, but we are talking about issues existing within one body. Let it be HQCJ or HCJ. I have an entire list of papers dedicated to specific topics. So when I applied my documents for this selection, I already switched my interest to HQCJ, and I published 3 articles. The first one was dedicated to the role of HQCJ within the Ukrainian judiciary, in which I analyzed the strategy for the development of the judiciary suggested by the president, which is already effective. Then I studied the issues of interaction. So you can see it from my answer that I focused on interaction between the bodies of judicial self-government and other bodies functioning within the Ukrainian judiciary. So I have 2 papers dedicated to these topics, and I'm also proud of my students who have different publications, who have published different papers on the judicial reform. 2 years ago, one of my former students published a paper and then presented her thesis, which was dedicated to responsibility for lack of respect to judges, for contempt of court, actually. So I helped my student prepare her paper and later her PhD. So that's the example. And I have many publications with regard to legal aid, legal support. Many of them were published in some foreign journals.
Well, if it's ever convenient to share the ones that have to do with the High Qualifications Commission with us, a citation perhaps, that would be welcomed. But thank you again for your time today. Let me turn you back to our chairman. Thank you.
Thank you. So, we don't have any further questions. Okay. Пане Владиславе, наша співбесіда добігає кінця.
Vladyslav, your interview is coming to an end.
Ми надаємо слово, заключне слово кожному з кандидатів.
We are giving our candidates an opportunity to express some concluding remarks. So could you please summarize? Is there anything important that you'd like to tell us? Or maybe you'd like to add something to your previous answers? You're welcome. Thank you. So, upon request of the Commission, I have provided copies of some documents proving the money that my parents have on their deposit accounts, and they have amassed these sums over their life. My mother was taking care of some elderly people, and she inherited their property after their death, and my father was giving tours. They had some concerts for which they were paid, and in late 80s and 90s, they went to Poland, just like many of fellow Ukrainian citizens did. They bought some goods in Poland, then they came back to Ukraine and sold them. And I studied at a school of music, and I was a member of a church choir. In the evenings, my father and I were musicians at weddings, and we were able to get between $300 and $500 per one event. So in such a way, we were able to accumulate the money which we used to later buy the apartments. Then we kept some of the money on the deposit accounts, and we received interest payments for having those bank deposits.
Щодо комісії, яку я маю за честь з вами, ви зі мною проводите співбесіду,
And with regards to the selection commission, I can tell you that it's an honor for me to be a candidate within this selection, to have this interview with the Honorable Commission. I completely support your approach, your tolerance, your respect for every candidate. I completely trust you, and I hope that you will use your professional experience for the best, and thank you. Thank you for your time.
Дякуємо вам, пане Владиславе. на доброму
Thank you, Vladyslav. Thank you for these kind words. With this, your interview has come to an end. All the best to you. Take care and goodbye. Thank you.